The new Supreme Court term isn't just a docket of fresh cases, but a referendum on the MAGA mandate. President Trump has thrown down the gauntlet, pushing the limits of executive power against the court he helped build. Our Amy DeLaura lays out the top cases of the new term.
The Supreme Court term will decide tariffs that could reshape global trade, a bid to fire a Federal Reserve holdout, birthright citizenship, and then that's all before the culture warriors descend on human sexuality, sports fairness, and election integrity. This month, the justices heard arguments in CHILES versus SALAZAR, a Colorado clash where a Christian therapist's faith collides with the state's iron-fisted ban on conversion therapy. Kaylee Chiles, a licensed counselor in Colorado Springs, built her practice on helping families navigate the turbulent waters of adolescence. But when a teenage client sought voluntary talk therapy to explore questions of sexual orientation and gender identity, questions rooted in the girl's own doubts, not some imposed agenda, Chiles faced a stark choice: affirm the state's progressive script or risk her license. Colorado's 2019 law, a darling of the LGBT lobby, prohibits any licensed mental health provider from engaging in practices aimed at changing a minor's sexual orientation or gender identity. A win for Chiles wouldn't just vindicate faith-based counseling, it could crack open doors for more faith-based advocacy nationwide, while also causing other states to reconsider their own conversion therapy bans. Two cases challenge Republican-backed bans on biological males who identify or are transitioning to females from competing in women's athletics. But the real flashpoint is the plaintiff in West Virginia versus B.P.J. A 12-year-old middle schooler named Becky Pepper Jackson, who transitioned at 8, was blocked from competing by West Virginia's 2021 Save Women's Sports Act, prompting a federal lawsuit. The NCAA counts fewer than 10 transgender collegiate athletes among 500,000, yet the bans ignite fury. Shifting from culture to commerce, November 5th brings Learning Resources, Inc. versus United States, a turbocharged tariff tussle that could make or break Trump's economic blitzkrieg. Trump invoked the International Emergency Economic Powers Act to slap 25% duties on $3 trillion in imports. Steel from China, cars from Mexico, and widgets from everywhere. A toy importer from Ohio sued, arguing that the IEEPA targets sanctions and seizures, not trade wars. The thorough line of most of the court's cases this term is presidential power, and no Kate pulses with it like Trump versus Cook, which will be argued in January 2026. Federal Reserve Governor Lisa Cook, a Biden holdover, became Trump's piñata. Accused of mortgage fraud, Cook refused Trump's pleas for rate cuts, provoking Trump to move to oust her. The District of Columbia Circuit Court of Appeals blocked her removal, citing the Fed's uniquely structured independence. A Trump win would mean the central bank can bend to White House wins. A Trump loss would be a rare check on MAGA's administrative state purge. October 8th's BOST versus Illinois State Board of Election probes mail-in voting madness, as it challenges Illinois' rule to allow counting late-arriving ballots. A narrow ruling could tighten the 2026 midterm elections, curbing the Democratic edge in big states. Looming largest may be Trump's Day 1 decree ending birthright citizenship via executive order.
That's a good one. Birthright. That's a big one.
As Trump aims to end tourism babies or anchor babies. A Trump win would upend United States versus Wong Kim arc and would allow the president to further curb illegal immigration. As the gavel falls on these battles, the big picture sharpens. What does this term mean for Trump's presidency, the MAGA movement, and the court's complicated legacy? As the justices deliberate, one thing is clear: Trump's America demands a court with the courage to match his. And the nation will be watching. I'm Amy DeLaura for Washington Examiner.